Good afternoon. I am Becki Young, and I'm a partner at Grossman Young and Hammond in Maryland. And I'm here today with my partner, Sandra Grossman, as well as two colleagues that we work with in the E-2 context. And we're here to talk about the E-2 visas. So I'll briefly introduce the folks that will be presenting today and give you a little outline of what we will be talking about, and then I'll start by introducing the E-2 visa itself. So I manage the Silver Spring office of our firm, and I'm a business immigration lawyer, so I help clients, companies, and individuals with a wide range of business immigration topics, including all sorts of working visas and green cards. And E-2 visas are definitely something that we see a lot of. Sandra manages our Bethesda office, and her practice focuses on the humanitarian side of immigration, as well on issues such as inadmissibility issues and complex consular inadmissibility, which means, for example, if you're going to apply for an E-2 visa, but there might be something that will trip you up at the consulate, Sandra is the person that you want to talk to. We also have with us today Marco Scanu, who is our business plan go-to guru. And whenever we work on an E-2 case, there are very specific requirements for the business plan. And so Marco always is the person that we go to. And then finally, we have Len Wolf, who is a CPA and an expat tax advisor, who is the person we always refer complex expat tax questions to. So thank you everybody for joining us today. And what we're going to do is start off with a brief introduction to the E-2 category and what it's all about. And then we will ask Len and Marco to each present on their area of expertise. Then Sandra's going to talk a little bit about what happens at the consulate. She will explain to you that there are different ways to file E-2 visas, but for the most part, they end up at the consulate. And so she'll talk a little bit about that. I will wrap it up, and then we will leave some time at the end for questions. So we do have an hour together today, and we look forward to getting started. And Andrea, can you advance the, are you advancing the slides or am I advancing? Thank you. Okay. So if you can please move to the first slide in the presentation. Thank you. Okay, so there are 9 requirements for an E-2 visa, and we're going to go through each one of them briefly. The first requirement is that there's a treaty. Second, that the applicant has the nationality of the treaty. Third, that there's an active investment. Fourth, a real and operating enterprise. Fifth, a substantial investment. Sixth, that there's no marginality. I'll explain what that means. 7, that the applicant, if they're the investor, is coming to develop and direct the enterprise. 8th, if they are an employee, that they're coming for an executive supervisory position or an essential skills position. And finally, that they intend to depart the US when E-2 status terminates. So if we can move to the first slide, we'll talk a little bit about treaties. So there's a list of treaties. If you Google E-2 treaty countries, you can see the full list. Basically, the United States has signed bilateral investment treaties with many countries around the world. And so we see a lot of E-2 visas from Western Europe. There are many countries in Asia, like Japan and Korea, Australia. We do many Canadian E-2 visas. We've also been seeing a lot of Latin American E-2 requests in recent years. And I just wanted to share with you a list of the Latin American countries that have treaties, because we don't see these as often as some of the others. So Argentina, Bolivia, Chile, Colombia, Costa Rica, Ecuador, Honduras, Mexico, Panama, and Paraguay. So those are the Latin American countries that have E-2 treaties, along with most of Western Europe and many Asian countries, etc. So if we can move to the next slide. The second requirement is that the individual or business possesses the nationality of the treaty country. So sometimes we work with big publicly traded companies, and then there's a presumption if the company is traded on the stock exchange of a particular company, country that the company has the nationality of that country. And sometimes we have to trace the nationality back to the individual owner. So if it's a family held company and the family members are not coming to the US, but we need to qualify the company, we would need to document the ownership of the company, and we would also have to document the nationality of the owner. So usually by corporate documents showing ownership, as well as the passports of the owners to show their nationality. And then the employees that you bring also have to have that same nationality. So if you're a Japanese treaty company, you can only bring Japanese E-2s. Let's take a look at the next slide. So the next requirement is that the applicant has invested or is actively in the process of investing. So basically an E-2 cannot be for a speculative investment. You have to be close enough to the start of doing business that once you get the E-2, you will commence business imminently. Sometimes, the best E-2 is a business that already exists, that's already operating. But if the business isn't already operating, you have to show active investment. And we did have an E-2 case one time that was for a gourmet food store, and the consulate decided that it was a good E-2, but they were not close enough to doing the start of doing business. They gave them a business visitor visa and told them to come back when they were closer to the start of business. So definitely you need to be already started or on the edge of doing business. Let's take a look at the fourth requirement. So real and operating commercial enterprise. So, I think we see this a lot. We get asked a lot if we can do an E-2 for a real estate investment. Can I buy a condo? Can I buy a commercial office building? And the answer in general is no, because the E-2 enterprise has to be a business. And I usually use the term bricks and mortar. You can see the bricks and mortar behind me today. So the E-2 was really created for businesses that are bricks and mortar type businesses, whether it's a store, whether it's a restaurant, whether it's a company, an architecture firm, a law firm, something, a company that has physical offices and employs people. Interestingly, there has been a recent addition to the rules which allows virtual offices. We have not tried one of those E-2s yet, and there was a conversation with a bunch of colleagues. It doesn't seem like many people have been filing E-2s. It is theoretically possible to do an E-2 with a virtual office, but it still has to be a real and operating commercial enterprise. It can't just be a passive investment. Let's take a look at the next E-2 requirement. So the next E-2 requirement is that the investment is substantial. There's nothing in the regulations to tell us what substantial is. And if you Google, what investment is required for an E-2, you'll get a lot of different answers. Our law firm generally feels comfortable with an investment of $200,000 or more. Again, that's not written anywhere in the law, but we have found that some investments of less than that amount are questioned as not substantial, but generally investments of that amount or higher meet the substantiality test. So that's our comfort level. You'll see many law firms who will say 100,000 is okay, and there are definitely investments of under 100,000 that have been approved. So substantiality is really a very subjective term, and you should really, if you're considering an E-2 investment, talk to a lawyer about the type of business that you're considering to see whether your investment would be substantial for that type of business. Let's look at the next E-2 requirement. So this is about marginality. So marginality says that the investor can not just start the E-2 business as sort of a subsistence level business. And there are two main ways that we show marginality. The first is by showing that this business, that the investor sort of has other assets or other sources of income so that they're not subsisting only on this business. But the second more important way is that this business will be creating jobs for US workers. So even you know, over the course of E-2 history, creating jobs for US workers has always been an important requirement. And when you show that your E-2 business will create jobs for US workers, you can use that to meet the marginality requirement. So the next E-2 requirement is that the applicant, if an investor is coming to develop and direct the enterprise. So there are E-2 applicants who are investors, and then there are E-2 applicants who don't own the business, but who are managers or specialists. So if you are an owner or investor in the business, you have to show that you're coming to develop and direct, which in essence means you're coming to oversee the business. So you can't get an E-2 visa just for the purpose of getting yourself to the US and then ignore the business. You do actually have to have oversight of the business. There's no requirement that it's a full-time job, but you do have to devote yourself to the development and direction of the business. The next requirement relates to an employee or manager applicant, and that person, if you bring an employee, they have to be actually going into a managerial role or into an essential skills role. And there is a provision in the law which says if they're going into an essential skills role, that it has to be for a finite duration, and basically they need to show that the role will end or that they're training US workers to eventually take over that job. Okay, and then we have one more point about the E-2, which is that the applicant intends to depart the US when E-2 status terminates. So the E-2 is what I would call a quasi-dual intent visa. So we have some types of visas like an H-1 or an L-1 visa that are clearly dual intent visa, and it's okay to have immigrant intent. You can go to the consular post and tell them you intend to immigrate, and they will still give you the visa. There are other types of visa like an F or a J. If you express immigrant intent, you're not going to get the visa. And an E-2 is sort of in between. So you do have to have an intent to depart the US. And in many cases, we will actually submit a statement from the applicant regarding intent to depart the US, but it's not as strict as in a J1 or F1 context. So those are the 9 basic legal requirements for the E-2 visa. And Andrea is going to be the person who's going to keep us on track today. So I am going to ask her, I believe Marco is going to speak next. And we have about 10 minutes for Marco, 10 minutes for Len, and then 10 minutes for Sandra. So Andrea, if you could do your best to keep us on track, we would appreciate it. And Marco, I will turn it over to you.
Well, thank you, Becki, and thank you for having me today. As Becki indicated, I'm Marco Scanu. I'm the founder and CEO of Visa Business Plans, and my company has now 12 years of experience in the field of business immigration. We have done now more than 6,000 immigration business plans, which means that we have learned a thing or two about immigration business plans. And the interesting thing about immigration business plans is that, when I have the first, let's say, call or conversation with a client, I would say 99.9% of our clients are business people or investors. And when they hear business plan, of course, they think, oh, yes, I can do this. But and since my background is in entrepreneurship and business, I understand where they're coming from. But what I want to talk about today is the biggest differences between an immigration business plan and any other type of business plan out there. So next, thank you. So I always like to begin this topic by speaking about the audience. This is all about the audience. What do I mean by this? When Becki and her team puts together an E-2 petition, they're going to send it to, let's say, a consular officer overseas, or in some cases, when they do a change of status or even a renewal in the United States, that petition will fall in the desk of an immigration officer. So it's really important and interesting to learn the background of these immigration or consular officers. So this is something that I've learned over the years. Number one, the top 3 college majors that they study are criminal justice, homeland security, or international law. So as you can see, in most cases, their background is not business, is not finance. So in most cases, these officers are not CPAs, they're not bankers, they're not investors. Next. Thank you. So this is what we have learned over the years. Let's say that on average, these officers take between 20 and 30 minutes to review cases. And one myth that I like to always talk about is, look, I understand that the business plans are mainly about financial projections, but these officers don't really care about complex financial projections and cash flow and revenues and profits and so on. They just want to understand your business. That's it. They really want to understand it, but especially they want to make sure that your business meets the E-2 law or the regulations that Becki was talking about before. So our main goal as business plan consultants is to make sure that the audience, immigration or consular officers, the audience feels smart. This is super important. One of the biggest mistakes I see out there is when investors put together their own business plans using technical jargon that nobody's going to understand outside the sphere of that industry. So this is super, super important. And in this process, as you can see, I added an image, the bottom right of this slide. Sometimes doing an immigration business plan it's like trying to mix oil and vinegar or try to put a square peg in a round hole. That's what it feels like in many cases. Next, please. So what is the business plan in the business world? As I said before, it's about 90% financials and maybe 10% narrative. When you're presenting the business plan to an audience, when you can interact with that audience, the audience will ask questions. That's the dynamics of a business plan outside of immigration. However, next please. In the context of immigration, an immigration business plan is the other way around. It's 90% narrative and just 10% some really basic financials that again address some of the requirements that Becki was talking about before. So first I want to talk about the narrative. Next, please. So we always like to think that, again, this is all about the audience, and we want to make sure that the audience, these officers, really understand the business. So the business plan is a vehicle to educate officers, and the narrative has to explain what the business is all about and how the investor intends to grow the business and when he or she intends to scale the business. What is the vision for the business for the next 5 years, but especially why the investor needs the visa. This is super important, okay? And what I find with many clients is that in the process of explaining how they work, I always emphasize the importance of providing details. An immigration business plan is about providing a ton of details about the day-to-day operations. Whereas any other types of business plans are usually at a higher level, again, compared to an immigration business plan, which is about, let's say, the nuts and bolts of the business. So again, the narrative is super important because, as I tell my clients, look, the officer that would read your business plan needs to understand your business plan, and forget about the officer asking you 50 questions about the business. They either get it and understand your business and really understand what your vision is, or you might be in trouble. So 90% of the business plan is the narrative, and then I want to talk about the financials of the business plan. Next slide, please. So as I said before, about 10% of the business plan covers the basic financials, and we basically focus on what I like to call the 3 pillars of the E2 business plan when it comes to the numbers, to the financials. Number one, the investment. And this is where I also have long conversations with our clients, because in the business world, when you present a business plan, the investment section is all about what you intend to do with the funds. So it's a projected type of budget indicating what your intentions are in terms of, this is how I'm going to spend the money. For E2 purposes, they want to see that you are in the process of spending the money. You are in the process of making the company operational. And as Becki was saying, you have to be as close as possible to opening the business. I like to tell my clients, look, the ideal scenario is that when you go for the interview, basically you're saying, look, I'm ready to go. I'm ready to open the doors of my business. All I need is the visa. As soon as I get the visa, I will open the business. And again, also as Becki said, the ideal scenario is a company that is already operating, has hired the staff, and is bringing revenue. So the investment section is one of the biggest areas where we spend a lot of time educating our clients and explaining, yes, I understand that ideally you want to get your visa without spending one dime, but that's not how it works. Welcome to the E2 world. The second point that we address in the financials has to do with marginality. So, job creation, depending on the business model and the type of enterprise and so on, can be direct or indirect. Ideally, we like to show some type of job creation. It is important for me to underline that we're not immigration attorneys. We will never provide any type of legal advice or anything that looks like legal advice. That's why when clients ask questions about, hey, can I hire this? Can I hire a 1099? I always say, look, go back to Becki and her team. They should be able to guide you on the staffing, on the best way to do the staffing for your company. And the third component or point that we address is what we call the investor income. And basically the concept is we want to show that the investor will be able to make more money than they can spend to live in the United States, always, of course, in coordination with Becki's team. As he said before, if the investor has other sources of income, they will address that in the petition. So this is all I wanted to share about E2 business plans. Thank you.
Thank you. And now we'll turn over to Len, who's going to tell us a little bit about E2 taxes, which is a subject near and dear to our hearts.
Right. Thank you, everybody, for organizing this and joining us. My name is Len Wolf. I direct an international and expatriate tax CPA firm in the Northern Virginia area. We have a presence in DC and in New York. And we do pretty much only international and expatriate tax work, inbound as well as outbound. So we've been working with E2 visas, e-visa holders, and every other visa holder for many years now. And I just wanted to give you sort of an overview of the tax implications associated with an E2 visa holder working here in the US. The very first thing we do when we serve an inbound expatriate is to determine his or her tax residence in the US. And I'll explain in a moment the implications of being a tax resident versus remaining a tax non-resident of the US. But the very first thing we do, and it is indeed very important to do first, is to determine whether or not the individual will be a tax resident of the United States or not, and if so, when that residence period will begin. Because tax residents are taxed very differently than tax non-residents, okay? There are two tests of tax residence in the US. The first is the green card test, and the second is what we refer to as the substantial presence test. So obviously, E-2 visa holders are not lawful permanent residents carrying green cards, so we know that they don't meet that test. The other test of residence is the substantial presence test. So we need to make sure that these people don't meet the substantial presence test while they're in the US, or if they do, at least understand the implications of that tax residence, okay? The substantial presence test is met if one is in the US more than 182 days over a 3-year period, with the days in the prior years weighted in such a way as to give them less of a contribution to the total 183 days than the days in the earlier years, the later years, excuse me, right? Who founded this formula, came up with this at the IRS? What they were smoking at the time they did is beyond me. I've never understood why this formula needed to be as complicated as it is, but it is what it is. And to determine if one meets the substantial presence test, we look to the number of days that the individual was in the US in the current year. So if somebody comes to the US on an E-2 visa in 2021, we count the number of days that he or she was in the US in 2021 in the entire calendar year. We add to that a third of the days that they were in the US in the prior year. That would be 2020. And we add to that a sixth of the days that they were in the US in the second prior year, 2019. If the sum of those three numbers exceeds 182, then that individual is a US tax resident under the substantial presence test for the current year, 2021. Okay, so you do need to look to how many days they were in the US in the current year, as well as in the 2 prior years, weight the prior year days accordingly, and see if the sum exceeds 182. If it does, that individual is a tax resident of the United States. And again, in a moment, we'll talk about the implications of that, okay? Keep in mind that any day of presence is a day of presence. So whether they were here in a prior year for vacation, or whether they were here in the current year visiting family and not necessarily working, if they were on a different visa, it doesn't matter. It's days of presence under any circumstance in the US. There are some exceptions for things like, for folks like ambassadors and the like, but certainly no exceptions for G4 visa holders, for E-2 visa holders, excuse me, okay? The other thing is we need to determine if they meet the substantial presence test, when does their residence period begin? Because they meet the test during the year does not mean that they are a tax resident for the full year. Their resident period begins on the very first day that they're physically present in the US in the current year, okay? So if somebody comes to the US on February the 1st and stays for the rest of the year, and let's assume they have no days of presence in the 2 prior years, they will clearly be here more than 183 days in the current year, more than 182 days in the current year. They will be resident, and their resident period will begin on February 1st, the first day that they arrived in and were physically present in the US. There is a 10-day de minimis rule, which is really designed for folks who say they came in February for 5 days into the US looking for accommodations. They went back to their home country, returned for full-time work, say on July 1st. They meet the substantial presence test for that year because they're here more than 182 days. They're allowed to exclude those first 5 days in February if they choose to, when they were only here looking for accommodation, so that their resident period does not begin February 1st, but rather begins July 1st, when they truly came to the US to work and stayed here in the States. Okay. Next slide, please. So if in fact an individual meets the substantial presence test and is deemed to be a tax resident of the US, it's important to note that he's taxed or she's taxed on their worldwide income. So during that time period, if they have income earned in their home country or income earned in any third country, as well as the income earned in the US, that's going to be subject to taxation to the US IRS if they're tax resident. If they fail the substantial presence test, they don't meet that more than 182-day, 3-year test, then they will be non-residents of the US, or they will, if you will, remain non-residents of the US. However, it's important to note that non-residents of the US are also taxed in the US. They're only taxed, however, on the income they earn in the US. So they're not taxed on their worldwide income, but they are taxed on their US source income. And salaries and wages are sourced where the work is performed. So if they're performing work in the US and they're earning income for those services provided, that is US source income. Any days they spend outside of the US does not constitute US source income, but any days in the US, there needs to be an allocation of their salary to those days. And that income is subject to tax in the US to those individuals. Okay. Next, please. There's one exception, and it's an important exception to the rule that I just stated, that if an E-2 visa holder is in the US and does not meet the substantial presence test, he or she is still subject to US taxes on any days that he or she actually did work in the US and had wages applicable to those days. And the exception exists if the US has a tax treaty, a bilateral income tax treaty with the individual's home country in which he or she has remained a tax resident. So somebody comes from Germany to the US, they're here temporarily on an E-2 visa. The laws in Germany might suggest that they remain resident for tax purposes in Germany. They therefore can avail themselves of the US-German tax treaty. And that tax treaty likely provides, and happens to be the case that the German treaty does provide, and most treaties do provide, an exemption from taxation for that US source income that I previously told you would otherwise be taxable in the US if they meet a couple of conditions. They have to be present in the US under most treaties, at least less than 140 days in the current year. So this is not a 3-year test. If in the current year, they're here less than 6 months, basically, okay? And they're paid by the foreign company, a foreign entity. And that cost of their salary is not transferred to a US entity and borne by the US entity, okay? If it's truly paid by the foreign company, and they're here less than 184 days, they can then exempt those wages from US taxation, okay? It's important, however, to look at each treaty because each treaty, while there are similarities between many and as much as they're based on a prototype treaty established by the OECD many years ago, they are all a bit different. So we do need to take a look at each treaty and confirm whether or not these provisions exist and what exactly they say. So in summary, once again, if somebody comes to the States, we first need to determine if they meet the substantial presence test and are resident. If they are, they're taxed on their worldwide income. If not, they're only taxed on their US source income, but US source income does include any income they earn for those days worked in the US. But then we look to the tax treaty if one exists between them and their home country. And if that treaty exists and says that those wages are now exempt, the treaty essentially supersedes the US domestic law, and those wages are no longer taxable in the US. So that's what I have, all I have on taxation. And I suppose we can move on to the next section.
All right, thank you very much, Len. And there are a few questions. We're going to hold them till the end, but I figured that this tax discussion would spark interest. So we'll ask you to address those questions when we get to the Q&A portion. And now I would like to turn this over to Sandra, who's going to talk about consular considerations. What happens when you go to the consular post to apply for your E-2 visa?
Thank you, Becki. Thank you, everyone. So we're going to talk about consular considerations because now you've gotten the great tax advice. You've gotten the wonderful visa business plan advice. You've spoken to us about the eligibility requirements. Are you done? No, you still have to submit your visa application packet and you still have to have it adjudicated. So we're going to talk about that in this section. Next slide, please. So there are two ways to file for an E-2 visa. If you're an individual that's in the United States, you can apply for a change of status with the U.S. Citizenship and Immigration Services. And if you are outside of the United States, you can choose to process through a consulate. So, for example, an applicant who enters the U.S. temporarily for business on a B-1 might investigate setting up a business, and that person could later apply to USCIS for a change of status to an E-2 and then lawfully operate that business in the United States. That said, in general and in non-pandemic times, applying for the E-2 visa at the consulate is overwhelmingly our preferred method of application. This is for several reasons. First, because if you apply for a change of status in the United States, the E is only granted for a 2-year period and it's not valid for travel outside of the United States, which can present problems for applicants. Two, consulates have a much greater expertise in properly adjudicating the E-2 visa. They usually have an E-2 visa unit and specially designated officers that have significant experience in interpreting the Foreign Affairs Manual, which has all of the guidance on how adjudicators should make decisions on E-2s. And over the past few years, we've noticed an uptick in applications and petitions filed with USCIS. You don't really know who is going to be adjudicating your E-2, and there have been increases definitely in requests for further evidence, which can delay your E-2 visa application, which is not to say that there won't be delays at consulates, but you tend to have a better sense of who you are dealing with. So all of that said, right now, due to the pandemic and temporary suspension of services of many consulates around the world, there are certain situations where it may actually be faster for those people in the US to actually apply for a change of status. Next slide. So when we talk about applying for an E-2 before a consulate, it's important to understand that the procedures vary greatly between posts and depending on the treaty that is in force. So for example, each consulate has very strict requirements when it comes to the submission of the visa application packet. In Mexico, for example, there are 2 consulates that are processing E-2 visas. In Ciudad Juarez, all of your documents have to be submitted in a 3-ring binder of not more than 70 single-sided pages, and binders must be divided into tabs A through G. Meanwhile, if you apply in Mexico City only accepts electronic submissions of no more than 100 pages. So, and there are vast differences, so in country and between countries. So you really want to make sure that you're working with your attorney to understand what you want to focus on in your E-2 visa application and that you adhere to the admission requirements. Also, it's important to understand the differences between treaties. And what I mean for that is best illustrated in an example. So, for example, the treaty between the US and the UK contains a provision that the applicant must reside in the UK. So when you submit an E-2 visa application at the consulate in the UK, the consulate will go through a qualitative assessment where they look at whether the person owns a house in the UK, if they have a job there, and whether their children go to school. And this comes up sometimes when we have, say, a dual citizen of, say, Venezuela and the UK, where Venezuela does not have the requisite treaty in place for an E-2 visa, but the UK does. Nevertheless, that person needs to have resided in the UK. Preparing for the interview is also incredibly important. While the lawyers will submit an application packet prior to the interview, which the consular officer will review thoroughly, the applicant must really know the contents of the packet and be able to talk intelligently about the business. The consular officer may ask about business growth plans that are detailed in the business plan, and really any other questions about the applicant's personal life or intentions. It's very important to tell the truth and to be prepared for your interview. Next slide, please. So prior to the interview, the applicant submits what's called a non-immigrant visa application form, which is a DS-160. That form asks numerous questions like the ones that you see here. It asks about your immigration status, what you're doing on social media, whether you have any communicable diseases or physical disorders, and then it asks a series of questions about your any potential criminal history. So it's incredibly important to be truthful and to fully disclose any issues that might come up with your attorney, and then to mark them appropriately on your non-immigrant visa application form. Failure to disclose any of this background can lead to not only a denial of the E-2 visa, but could also lead to revocation of a current tourist visa that you might hold, and could compromise future applications for visas. We also know that consular office have access to and review law enforcement databases for each applicant. Again, another reason to be very forthcoming. And then another dynamic is that consular officers often Google applicants to see what comes up on them online. So if you're aware of any challenges online, again, that's something that you want to properly vet with your attorney and take some time in reviewing. Next slide. So after a visa interview, a case may be approved, denied, or placed in administrative processing. If the application is denied, the consular officer should usually provide a visa refusal worksheet, which will give you an idea of why you were denied. If the case is placed in administrative processing, it usually means the officer needs to conduct additional background checks or investigations. So in regards to denials based on past criminal conduct, it's important to understand that no conviction or arrest is actually necessary to be denied for a visa based on criminal inadmissibility reasons. The standard in the immigration laws is very broad. And in cases that have to do with money laundering, drug trafficking, or terrorism grounds, for example, the only standard the officer needs to meet is a reason to believe that the person may be inadmissible. And that's a very broad standard, and it's broadly applied. So I'll just mention briefly that in cases where an applicant may have an inadmissibility issue, the good news is if they're forthcoming about it, there is a waiver available. It's a waiver that allows for entry of the person in the United States if they can show that they're coming in for legitimate reasons, such as to run a business, that they merit the visa as a matter of discretion, so they've been rehabilitated from any past criminal activity, and that they don't pose a threat or harm to any citizens of the United States. Next slide, please. So visa validity. Depending on the treaty and visa reciprocity schedules, consulates will issue visas for a defined maximum period of time. So as you can see from the case examples we put up here, the visa validity dates can vary. That said, whether or not to issue an E-2 for the maximum period of time is solely the judgment of the consular officer. And it really depends on the type of visa, on the individual's background. So for an established business, you might get a longer validity period than, say, for a brand new, smaller company or investment. It's also important to note that even if a US consulate issues you a visa, which is valid, say, for 3 years or 5 years, the immigration officer at the port of entry when you're coming to the United States will only give you permission to stay in the US for a maximum of 2 years. This is because a visa only gives you permission to come to the US and ask for entry in a particular category. The length of time that the visa is valid for is the length of time that an applicant can leave and re-enter the US in that particular category. So for example, for an E-2 visa holder, which is given a maximum of 2 years, they will need to plan to make a trip outside of the US to return prior to the expiration of the E-2 visa. Every time an E-2 visa holder is admitted to the US, they receive another 2-year period of authorized stay. Next slide. So what is the status of the consulates currently? The State Department suspended routine visa services worldwide in March last year due to the global pandemic. They are now going through a process of phased reopening with a prioritization for US citizens, followed by emergency and mission critical services. So all of this means there is a long line to get an interview. Many posts are currently not processing E-2 visas at all. There was some opening in Mexico a while back, and it seems to have shut down again. Now, there are certain exceptions if an applicant can show that they qualify for an exception or if it's in the US national interest. We are not able to provide a specific date for when the consulates will reopen. I think this will be largely dependent on when State Department officials receive their vaccines and on the pandemic conditions in each of the countries. That said, it is increasingly important for people who are interested in applying for the E-2 to prepare their applications and at least get their place in line. Thank you.
Thanks, Sandra. And I'm going to wrap up our conversation, and we've been answering questions throughout, but we'll be happy to take any additional questions that you guys may have. But I wanted to touch on the last thing that Sandra said. We'd actually gotten a question about whether there was a premium processing option available at the consulates, and the answer is generally no, although as Sandra pointed out, you can sometimes get an expedited appointment. In non-COVID times, I would say it's pretty rare to get an expedited appointment. You would have to show a really high level, like perhaps your company that you're establishing is going to work with the US military on a military contract, and there's some sort of national security or national interest reason. But in general, you have to have a very good reason, even in non-COVID times, to get an expedited appointment. And that would be even more true now. So, you know, many of the consulates are only issuing emergency appointments, and it can be very challenging. The other topics I wanted to touch on briefly were national interest exceptions and travel bans. So this is not E-2 specific, but there are still many countries where there are travel bans to the US in place. So for example, the UK, Ireland, and all the Schengen countries in Europe, as well as Brazil, South Africa. If you're in one of those countries within 2 weeks prior to coming to the US, you cannot enter the US. So in order to enter the US, you either have to go to a third country for 2 weeks, or you have to get what's called a national interest exception. And the national interest exception is largely outside the scope of what we're discussing today, but the criteria are based on critical infrastructure. So similar to what I was mentioning before, if you have a military contract, if you have something that's important to the federal government, probably if you had something related to COVID research or something that would, you know, impact health, that might be a reason to get a national interest exception. But, you know, in order to get an E-2 visa in Schengen or any of the other banned countries these days, you would need a national interest exception. The other topic I wanted to touch on is Buy American, Hire American. So you may have heard this term, we call it BAHA. and it was introduced during the prior presidential administration. There's always been a requirement of job creation for E-2 visas, but it's never been explicit. It was more just sort of a concept that your business should create jobs for US workers, but not so concrete. And during the prior administration, there was a major focus, the FAM, the Foreign Affairs Manual, which is the State Department's guidance, was updated to specifically mention Buy American, Hire American, and consulates were very focused on hiring plans for US workers. I know Marco actually added a Baja section to his business plans to address these questions. And the current administration has dialed back on Baja. So although it is still, a priority that your business will create jobs for US workers, it's not maybe an obsession as it was during the prior administration. And as Sandra has mentioned in the chat here, E-2 dependents will get E-2 visas, and the spouses are eligible for work authorization. So that is a really nice feature of the E-2 visa. There are not many non-immigrant visas that allow for spousal work authorization, but this is one of them. So I know that we have a few tax questions, and so I'm going to ask Len if he can address. Someone said, first of all, what will be the case, and I'm going to put this in the chat and I'll read it out to you as well. What will be the case if I provide asset management services for an EU company that I'm the owner of? Will it be my compensation that might be taxed in the US, or can it be the EU company's revenue as well? So I don't know, Len, if you have enough information to address that question.
Probably not enough information to address the question, but you're providing it. Read the question again if you wouldn't mind, just to be sure that I've got it all.
It says, what will be the case if I provide asset management services for an EU company that I'm the owner of? Will I be taxed on my compensation, or could the EU company revenue be taxed as well? I mean, it seems to me that your worldwide income could potentially be taxed.
Right. Yeah, no, I've got it. The wages that you earn as an advisor in the U.S., since you're physically working in the U.S., would indeed be subject to U.S. tax. But also, it is indeed possible that the British company that you're working for itself now is conducting business in the United States through you, and a portion of its global revenues could be subject to U.S. taxation. It's one reason why foreign companies in those circumstances very often do set up a U.S. subsidiary to segregate all of the U.S. source income that the company expects to generate in the United States. Because otherwise, indeed, you do have a foreign company. They may or may not have what we refer to as a permanent establishment in the U.S. There could be a tax treaty that excludes any income from taxation that is earned in the U.S., but you'd have to look to the treaty. But the general rule is you have to be very cautious about that, because indeed the company could be generating corporate revenues allocable to the U.S.
Okay, thank you, Len. And here's another tax question. Again, I'm not sure whether we have enough information to answer this. It says, how are retirement, pensions, and dividends from a foreign company handled for non-U.S. residents? So I guess the question is, if you're not a U.S. tax resident, what would be the tax treatment of retirement, pensions, and dividends from a foreign company? Do you have any thoughts on that issue?
They would generally be foreign sources of income. The pension, because the wages that generated the accrued pension benefits was presumably earned abroad, and dividends presumably are from non-U.S. companies. So all of that would be non-U.S. source income and not subject to tax in the U.S. if the individual in the U.S. was a non-resident of the U.S.
Got it. So here, I'm going to address this question. If you're applying for an E-2 for a previously existing foreign entity, do you put forward the documentation demonstrating the success of that entry abroad? does the consulate prefer that documentation is added to the packet? And I would say yes, if the business, you know, is in existence overseas, we would definitely show its success and its track record, because the biggest part of the E-2 visa when you apply at the consulate is to convince the consular officer that you know what you're doing and that you're competent to run this business. So that's where Marco comes in and presenting a business plan to explain in a narrative form. But also, if you can show that the business, you know, group has a track record of success, that will definitely help your case. Sandra, you can maybe address this question about whether family members could come to the U.S. Before.
Thank you, Becki. I don't see the question, but it's just asking about family members.
Yeah, whether NIV dependents can enter the U.S. before the principal.
So I think the answer to that would be no. I think you would need to first get, the principal would need to apply for the E-2, have it granted, and then at that point, the family members become derivative e-visa holders and would then be eligible to come in. So no, the principal has to first apply for and obtain the E-2 visa.
Yeah.
And usually the family members go with the principal to the interview.
Indeed. Someone's asking whether the E-2 is the appropriate visa for investing in a U.S. business. I would say the E-2 is definitely the best visa available for investing in existing U.S. businesses. So if you're considering and investing in a existing U.S. business and you have treaty country nationality, this could be a very good option for you. So I think that looks like all of the questions that we have today, and we are just about out of time. So that has worked out very well. We thank you all for joining us. I thank Sandra and Marco and Len for presenting this afternoon. And if you do have any follow-up questions, we will be posting this on our website along with all of our contact information, and you should feel free to reach out to us. So thank you, everybody, and have a great afternoon.